Thank you so much. Okay, I'm okay. Okay, ladies and gentlemen, Mr. Professors and Mrs. Professors, dear guests, and so on and so on. Allow me to begin with Thanksgiving, of course. I would like to thank the organizers for the opportunity for me to be here, to participate in this conference and in the whole Central European Professors Network. The title of my presentation is as follows, of course, and I'm more the dogmatic lawyer, so I'm not a philosopher, so barba philosophum not fecit, as you can see, so I will try to stick to the to provisions. Of course, like every lawyer. The concept of sanctions is the first moment in my presentation, let's say. And let me introduce a kind of definition of this concept. It refers to negative legal consequences or inconvenience resulting from the addressee's failure to comply with an order or prohibition established in legal provision. In this case, I mean, in case of my presentation, the grounds for imposing sanctions result from Article 7 in connection, of course, with Article 2 of the Treaty on European Union, hereinafter TEU. So, therefore, these sanctions are imposed in particular when the Council determines that there is a clear risk of a serious breach by a member state of the rule of law value, or the European Council determines the existence of a serious and persistent breach of that value. I think that's known for all of us. At the outset, it should be clarified that the following remarks will refer not only to those sanctions that reflects the commonly accepted terminological convention under Article 7 TEU. As it sets out, the sanctioning mechanism and the sanctions themselves result only from Article 7 para 3 or point 3 TEU. However, the assumption for me and for further considerations is that negative legal consequences for a member state breaching the rule of law value may also constitute an indirect legal consequence of the application of Article 7 para 1 and para 2 TEU, i.e. Declaring a clear risk of a serious breach or a serious and persistent breach of that value, so the rule of law value. The granting of discretionary power in Article 7 TEU, of course, in my opinion, raises the question of its legally defined limits. It is therefore worth considering what additional factors should delimit the choices the Council and the European Council make under Article 7. Of course, it is primarily about the general principles and the values of the EU law, especially the principle of proportionality as a value-weighing mechanism, but also rule of law, its individual elements or sub-principles, loyal, sincere cooperation and mutual trust between member states and the EU, primacy of EU law, subsidiarity in the sense of treating Article 7 as the final option or ultima ratio, national identity or effectiveness of law. Moreover, the European Parliament, in the report of 2004 on the communication of the Commission communication on Article 7 of the treaty, drew attention to another group of values that deserve to be taken into account when applying Article 7 TEU, and also called directly European Council and the Council to respect those values, let's say. These are as follows: the EU confidence in the democratic and constitutional order of all member states and in the ability of and determination of their institutions to avert risk to fundamental freedoms and common principles, plurality of ideologies, political objectives and values, and the democratic competition between them, which means, according to the report, that Article 7 shall not be treated as an instrument of political opposition, strict equality of treatment of all member states, credibility of the decisions taken by the EU institutions, and transparency of procedures. The next set of values is identified by Article 7, para 3 TEU, which provides for the obligation of the Council, when deciding to suspend certain of the rights deriving from the application of the treaties to the member state, to take into account the possible consequences on the rights and obligation of natural and legal persons. In other words, in the process of balancing values in accordance to the principle of proportionality, values underpinning these rights and obligations must also be taken into account. And in my opinion, this should refer, this obligation to take them into account should refer not only to the mechanism of Article 7, para 3, but also to the whole Article 7, the other mechanisms deriving from this provision. The above-mentioned catalogue of values is, of course, of a general nature and will be subject to specification on the basis of specific facts related to a given member state, being the addressee of the mechanism of Article 7 TEU. As Professor Kochenov stated, the basic consequences of implementing Articles 7, para 1 and 2 TEU is naming and shaming a member state in question. This may have an impact on political, diplomatic and economic relations with other member states of the EU. But sometimes the EU law directly or indirectly refers to the consequences of applying Articles 7, para 1 and 2 TEU to a given member state. The first example is provided by the TFEU Protocol number 24 on asylum, and so on, the title. Pursuant to its sole article, all member states as a rule, shall be regarded as constituting safe countries of origin in respect of each other for all purposes in relation to asylum matters. Therefore, any application for asylum made by a national of a member state may be taken into consideration or declared admissible for processing by another member state only in exceptional cases. Among them, the protocol mentions the situation when the procedure referred to Article 7, para 1 TEU has been initiated, of course with regard to the member state of which the applicant is a national, or the second situation, the Council has adopted a decision in accordance with 7, para 1 TEU, or the European Council has adopted a decision under 7, para 2 TEU in respect of course, in respect of the member state of which the applicant is a national. Another example flows from the Council framework decision on the European arrest warrant. And against this background, the effects of the application of Article 7 TEU were clarified by the CJEU seminal judgment, case reference C216/18, famous also for Poland. In the court's view, if the European Council has found a serious and persistent breach of the value of Article 2 TEU in a member state issuing the European arrest warrant, and the Council has subsequently suspended the application of the framework decision towards that country, the judicial authority executing the warrant is required to refuse automatically to execute this warrant. Other cases under Article 7 TEU, the judicial authority executing the EAW should treat only as an information, indicating that there is a risk of breach of the fundamental right to a fair trial. This authority should then independently examine and assess, firstly, the existence of a real risk of violation of this fundamental right due to systemic or general shortcomings in relation to the judicial authority, and secondly, whether there are serious and proven grounds for considering that the pursued person will be exposed to that risk. Only after such determinations and assessments, the executing judicial authority may refrain to give effect to an European arrest warrant. Pursuant to Article 7, Para 3 TEU, the Council may decide to suspend certain of the rights deriving from the application of the treaties to the member state in question, including the voting rights of the representative of the government of that member state in the Council. So, this provision rules expressly that the suspension might concern the voting rights of a member state in the Council. The consequences of it are specified in detail in these articles which you have on the slide. Article 7, Para 3 TEU does not indicate directly what other rights may be subject to suspension. However, this only applies to certain of the rights. Thereby, this regulation does not allow for suspension, of course, of all the rights of a member state, nor may it lead to the exclusion of this state from the European Union. From the general definition of application of the treaties, it can be assumed that this applies not only to the primary law, but also includes the rights granted by the secondary EU law. In other words, all binding sources of the EU law authorized by the treaties. In other respects, the subject of the rights to be suspended is undefined. Therefore, a broad interpretation of these rights is proposed, and examples from the literature, for example, Professor Dąbrowski, Potaks, Professor Taborowski, the examples include rights of political, economic, or other nature, such as participation in the functioning of EU institutions, for example, a right to vote or participate in the meetings of EU bodies and institutions, submit applications to them, suggest candidates or nominate their members, receiving payments from the EU funds, obtaining loans and guarantees from the European Investment Bank, benefiting from freedoms of internal market, automatic recognition of judicial decisions in other member states, or as I said about it previously, participation in the mechanism of the European arrest warrant. In particular, one of the sanctions resulting from Article 7, Para 3 TEU could be prima facie the suspension of the right to bring an action against an act of the EU before the CJEU. However, it is a fundamental right protected under primary law as a general principle of the EU law and the rule of law element. Therefore, in my opinion, the view of Professor Taborowski deserves approval that it is difficult to accept the imposition of a sanction which is in clear contradiction with the founding value of the EU and which is intended precisely to realize this value. It should be therefore assumed that the limit for determining negative consequences under Article 7, Para 3 TEU is the Council's respect for the EU values listed in Article 2 TEU. The control competences. The control competences of the CJEU in relation to the rule of law protection mechanism are determined primarily by Article 269 TFEU. According to this provision, the Court of Justice shall have jurisdiction to decide on the legality of an act adopted by the European Council or by the Council pursuant to Article 7 of the treaty, and in respect solely of the procedural stipulations contained in that article. Hence, the legal remedy appears as a special type of annulment action with a specific object: the acts adopted by the Council and the European Council on the basis of Article 7 TEU. But it should be emphasized that the reasons for their annulment are confined only to procedural aspects. For example, the Council decided without the consent of the European Parliament, or the voting rules were violated, and do not cover this jurisdiction the material aspects of the controlled acts. For example, selection of type of sanctions, application of the principle of proportionality, fulfillment of the substantive conditions for the application of Article 7, including the adopted definition of the rule of law. It's out of control of the CJEU. As indicated above, the jurisdiction of the CJEU covers only the acts of the European Council and the Council. And these acts are the Council's recommendations under Article 7, Para 1 TEU, the Council's determination that there is a clear risk of a serious breach of the rule of law value, the European Council's determination of a serious and persistent breach of the rule of law, the Council's decision of suspending certain of the rights deriving from the application of the treaties, and finally, the Council's decision to vary or revoke the latter sanction. But the other acts adopted under Article 7 may be subject to the general action for annulment provided for in Article 263 TFEU, but specifically co-applied with Article 269 of the TFEU in a way to preserve so-called effet utile of the latter provision. It means that Article 263 cannot deprive the limits of jurisdiction provided in Article 269 TFEU. In this case, Article 263 concerns all acts of the EU institutions initiating the mechanism of Article 7 Para 1 and Para 2 TEU. In my opinion, a complaint under this provision is unlikely to be available against the European Parliament consent expressed on the basis of both provisions of Article 7 TEU. And final remarks. Applying the legal criteria for assessing the above regulations, certain critical remarks can be formulated towards Article 7 TEU in terms of legal consequences of a member state conduct established therein. These remarks are as follows. 1. The problem is that the full extent and nature of sanctions under Article 7 Para 3 is not clear. The provision leaves a wide scope of discretion to a political body, and the body is not a court, with no clear boundaries drawn by the legislation itself. 2. It is also controversial that the legal consequences determined by this political body, which may seriously interfere the legal situation of the state and individuals, are subject only to a narrow scope of control of the CJEU, covering only procedural issues. 3. issues remaining beyond judicial control are extremely important and include the selection of the type and severity of sanctions, the correct application of the principle of proportionality, and even the existence of substantive premises for establishing the negative legal effect. And 4, this quite obviously conflicts with the principle of effective judicial review, which is an element of the rule of law, of course. Thank you for your kind attention.